Right, good morning everyone and welcome to DeHavilland and Inline Policy's second joint event, this one exploring the EU Data Act. My name's Andrew Himsley and I'm the CEO of DeHavilland. For those of you not familiar with the business, we provide policy monitoring and stakeholder mapping services across Brussels and beyond, helping organisations understand, keep up to date and engage with the legislation process. It is undeniable that the subject of today's event is very important and topical. As recently as yesterday, the European Parliament adopted the AI Act, and we see more and more steps being taken to push the digital transition. That's what this event is about, exploring the opportunities of the Data Act, an important digital milestone in the EU that will foster a competitive market, make data more accessible and boost economic growth, goals that I'm sure most want their organisations to align with. I look forward to hearing from the distinguished panel we've assembled, who I'm sure will do an incredible job discussing this complex piece of legislation. Again, thank you for joining us. Our expanding events programme is an important way for us to engage further with the industry, and we are excited to be working with Inline Policy once more. I'm therefore delighted to hand over to Shomik Panda, CEO of Inline Policy, who will be chairing today's session. Thank you, Shomik.
Thank you, Andrew. Delighted to be here myself, moderating today's exciting panel entitled The EU's Data Act, How Can Policymakers and Businesses Benefit from the New Data Regime? And it's wonderful once again to be working with DeHavilland, our event partners on this, and we're looking forward to another excellent debate. The format of this morning's event will be that for the next half hour or so, the panel will answer curated questions related to the Data Act before we open up to questions from the audience. The panel is going to give an overview of their perspectives on the legislation before we take a deeper look at some of the themes contained within the Act, including data sharing and portability, intellectual property, and how the Act interplays with other pieces of EU law. We're really lucky to have four of the foremost experts on data policy from the political and corporate worlds with us today, and it's my pleasure to briefly introduce them to you before we dive into today's discussion. So in alphabetical order, first of all, we have Damian Boeselager, MEP. Welcome, Damian. Damian is a German member of the European Parliament for the Greens Group and co-founder of the pan-European federalist political movement, Volt. He works on data policy and AI and was shadow rapporteur for the Data Act in the European Parliament's lead committee on industry, research and energy. Welcome. Next, we have Federico Milani, who is the Deputy Head of the Data Policy and Innovation Unit of the European Commission's Directorate General for Communications, Network, Content and Technology, or DG Connect. Federico's unit is responsible for the EU's strategic research and innovation agenda. He's previously worked as Deputy Head of Unit for several field-related units, including Content and Safer Internet, Cultural Heritage and Technology Enhanced Learning, and Data Applications and Creativity. Welcome, Federico. Olga Nowicka is the Senior Public Policy Manager at Workday, the leading provider of enterprise cloud applications for finance and human resources. Based in Brussels, she serves as Workday's policy lead on a number of EU digital policy files, including the Data Act. And in the past, she has worked in the private and public sectors, focusing on topics related to sustainability, digital trade, and lawful access to data. Welcome, Olga. And last but not least, Jeremy Rollison is Head of EU Policy within Microsoft's Corporate External and Legal Affairs Group. His work focuses on policy related to EU regulatory frameworks for digital, cloud, and increasingly AI take-up for Microsoft's customers in Europe. Jeremy has over 15 years of public policy experience and has worked previously on data, AI, privacy, cybersecurity, cloud, intellectual property, and copyright issues. Welcome, Jeremy. So, speakers, I'll kindly ask you to keep your answers to 2 minutes each so that we leave 20 minutes for Q&A from the audience. And audience members, if you would like to ask the panel a question, please submit your question through the Q&A function and specify who you'd like to ask the question to. I can't promise that we'll be able to take all of your questions, but we're going to take as many as we can in the last 20 minutes. Lastly, as you know, this event is being recorded, and we're going to send a link of the recording to all of those that have signed up to the event after we're done. So with that, let's kick off. and I'm going to start with a really short summary of the state of play for the Data Act. In February 2022, the European Commission published its draft Data Act proposal. This was subsequently debated and amended in the European Parliament and the Council of the EU. The European Parliament adopted its position in plenary in March 2023, and the Council of the EU also reached agreement in the same month. The three European institutions have now entered the trilogue negotiations, which are ongoing. So my first question is to Federico Milani. Federico, as we've got several people tuning in who are not necessarily familiar or so familiar with the proposed regulation, could you please remind us of the European Commission's main objectives for introducing the Data Act and the key proposals that are contained within it?
Well, the main objective of the European Commission to introduce the Data Act is very simple. What we want to stimulate is the sharing of data, because we believe that all the data that is collected, especially in the industrial data, is used by the organization, the manufacturer, or the organization, or the manufacturer more specifically of IoT systems for specific purposes. But that same data can be used for other secondary type of use in order to provide better services to the users of the IoT devices, the smart devices that are using this device and therefore generating data. We noticed that there are difficulties on getting access to this data, and therefore with the Data Act, what we are trying to do is to really push manufacturers to make more data more accessible. But at the same time, we want also to preserve the and to give the possibility to the manufacturer to continue to use that data and to have a control to whom this data is going to, and the possibility, therefore, and to have the trust that this data is not going to directly compete with the activities, the economic activities that these manufacturers are doing. We have also introduced other aspects, which is again tackling the issue of unfair contractual clauses in data sharing, which again many small medium enterprises has pointed to us, because when dealing with a major company, major organization, they do not have the possibility of having access to negotiate the contract for sharing data. We have also set up a number of clauses for the possibility of switching from cloud to cloud services, so that again the users of cloud services will not be tied up with a specific cloud service provider, but can easily switch between different cloud service providers in order to again improve the competitions on this market. And then we've also covered another aspects, which it's really coming up from a work that we've done that actually finished before the COVID pandemic, but then the COVID pandemic even brought it into light even more, which is the possibility of governmental organization to have access to business data when there are major risk and crisis involved, so that they can take much more informed decisions based also on data that is accessible, data that is stored and that it's there, but it's not really accessible easily and in a very fast way as in this type of crisis. And I stop there because I think my 2 minutes are finished.
Thank you, Federico. I appreciate it. We'll move to the Parliament now then to get their perspective. Damian, what are the priorities of the Parliament in the trilogue negotiations?
I mean, as Federico explained there quite a lot. Hello, everyone, and thanks for inviting me. So, yeah, I think like if you look at the B2G chapter, there were some where we basically focus on the fact that we don't want, random data to just be asked, even though the crisis is not really here. So to really focus on emergencies, we also said that we don't want personal data to be shared from businesses to governments in that aspect. But the area that I focused more or most on was actually the B2B part. So the question of, how do we structure the data sharing in between businesses when it comes to connected devices? And I think there we have a very interesting parliamentary position where we basically say, look, we need to untangle a couple of things that the European Commission, I think, rightly proposed, but where maybe it's good to clarify, because in the end, our goal is to have liquid data markets. And to get to liquid data markets, you need to have clarity for those who can potentially share data, what kind of data they can share and what kind of data they can't share. And so what we propose in the Parliament's position is first to walk a bit away from the idea that you as a product owner should know every data point that's going around in that product. So we went away from the in-device data access law, if you want. And the second point is that we clarified the roles. So we said, look, there's a manufacturer and certain obligations to a manufacturer. There is a user of a device that we also connected more with property rights. So the owner of that device or someone who has gotten some of these data access and sharing rights from the owner. And then you have the data holder, so someone who's, I would call in more modern terms, an operator of that device. So someone who receives data, but also sends data back into a connected device. And then you have a third party that you can call a data recipient that somehow gets access to that data. And that was a bit like the structure we tried to bring in. Then we also tried to differentiate between the contract of buying a device and operating that device. So basically a purchasing contract versus a servicing or licensing contract of some sort. And then we tried to differentiate who has what kind of rights to share what kind of data, so that we get the incentives that people actually want to share data on data markets. And I think with that, I stop. I mean, this is the rough, the architecture that we try to lay behind the B2B chapter. There are, as Federico said, other chapters, but I'll just focus my intervention on this right now.
Thank you, Damian. Very helpful. I'll move to Olga and Jeremy. From the corporate perspective, what are the main benefits and challenges that you see arising from the Data Act proposal? And given that we don't have any representatives from the Council of the EU, is there anything from the Council's position that you would like to particularly highlight as beneficial or problematic? Let's go first to Olga.
Thank you, Shomik, and thanks for the invitation to join the panel. So we, as Workday, as mentioned, as a provider of cloud applications for HR and finance, the key focus for us is really sector-safe cloud switching. And as Mr. Milani mentioned, one of the key objectives is really to make it easier for customers to switch from one provider to another. So at Workday, we are definitely supportive of this objective. And what we find especially beneficial is the provisions that customers can retrieve their data in a fairly timely and straightforward process. And I think most importantly, free of charge. So this is definitely what we find beneficial. When it comes to challenges, I think one of the biggest challenges we've seen is that some of the provisions in Chapter 6 did not really account for the complexity and diversity of the cloud market, in our view. And I think there are significant improvements on both co-legislators' side to address some of these issues in Chapter 6. But if you ask me specifically on the Council side, I think what we see very positive is that the member state mentioned fixed-term contracts as a viable option for contracting for providers, especially in the B2B context. And what we appreciate is that they also allow providers to recuperate at least some of the initial investment that goes into onboarding of customers through early termination. So maybe just to give you an example, we see our customers, which are predominantly large customers, to switch between 6 and 18 months. So there's really significant resources that go into making sure that this onboarding process is successful, which is why this particular provision on the council side is key from our perspective. So let me pause here and hand it to Jeremy. Thank you.
Jeremy, I'll bring you in at this point.
Sure, and I can agree with a lot of what Olga mentioned. You know, we have priorities across the text. You know, I think the cloud switching rules that Olga referenced, I think it's something we've focused on, and you know, where we are in the process now, I think we are already starting to look forward to the compliance phase of this. And so the high level message, I think, is that while there have been some improvements, and we can get specific about a few of those, I think there's still a large degree of ambiguity with some of the terms, and it has been a bit challenging to explain to engineering teams and compliance teams, you know, what actually needs to be done, what some of these words mean. There is a lot of complexity that Olga mentioned, and I think it hasn't necessarily been adequately addressed through some of the different chapters. The cloud switching text, I think the Parliament has introduced some improvements there, some clarity, Council as well. And we're waiting to see what the final result is on that, because as Olga said, I think we all kind of can agree on the what, but the how, especially around concepts like functional equivalence and some of the implications for fixed term, long-term contracts, you know, we still have some question marks around that. And I think some of that will be sorted out in the implementation phase. But obviously that's never as ideal as having some clarity from the start. On the B2B sections, I think our main concern there is, you know, we have a lot of customers who are concerned about potential implications for their trade secrets. I think our concern is, of course, reflecting where those views are, but also how those definitions may capture, you know, the ecosystem of providers that technically hold some of that data. So when Damian mentioned earlier that, you know, it's really the operator of the device, I think that's helpful clarity, because we do have customer data for which we might not even know whether it constitutes a trade secret. Us and chip manufacturers and others, developers, may technically hold the data, but what would our obligations be in that context? So I think the Parliament introduced some helpful clarity there that we see as an improvement. I'll stop there just to keep it short, but I think on cloud switching in particular, we still have some question marks as we look to compliance and trying to understand what all the terms mean in more of a compliance phase.
Thank you, Jeremy. Okay, let's move on to the topic of data sharing and portability. Federico, the Data Act aims to ensure data sharing contracts do not include unfair clauses. Could you elaborate more on how this is achieved in practice and how this provision would impact existing contracts? And additionally, under Chapter 4, the data holder bears the burden of proving that contract terms were not unilaterally imposed. Do you see any particular risks with this?
Well, first of all, Chapter 4, as you said, is making the provision of it's helping, it's built there in order to support small medium enterprises that identify that there is sometimes an issue on the possibility of accessing data, and when they struck a deal or when they are negotiating their position in order to get access to data with major or with bigger data holders, they are confronted with a position where they cannot negotiate, but they have to accept the offer provided by the major companies, big companies. So what we are planning there is to set up a system where we will be able to provide information on which could be these contractual terms that we consider unfair. So provide a list of those terms, unfair terms that can be used in a contractual agreement, and also provide what are possible contractual terms that can be considered, that can be used. So a model contract, a model contract agreement that can, with some terms and rules that can be used. We think that the issue of having the data holder demonstrated, especially if it is in this strong position, demonstrating that that is not that what is offering is not unfair, is because again, we are confronted in a situation where small medium enterprises, which are not most of the time supported by a legal support, and therefore I have got much more difficulties interpreting the contract, will have a disadvantaged position. By the data holder providing this information, I think we are putting both the small medium enterprises and the data holder in a more balanced position. The establishment also of the dispute settlement bodies will also help to settle these issues, and therefore we are trying to set up a system that will be able to address all these issues that has been pointed out in the past.
Thank you, Federico. Damian, on B2B data sharing, do you think the proposed Data Act strikes the right balance between making a data available, especially to smaller players, whilst also protecting trade secrets and stimulating innovation?
You know, one reason why I also wanted to attend this event is because I actually liked the title of the event, because it was talking about opportunities. And I think one perspective that we need to look at is the perspective of opportunities and innovation that you also just mentioned in your question. And I think if we shouldn't forget that goal. As I would actually invite all companies that own some form of a connected device to put not only their compliance officers but their business strategists behind it, and have a look what kind of potential could come out from that data that potentially you would have access to if you own that device in the future. So let's see what the trilogue's outcome will look like. But I think to look at it from a data is worth something if it's shared. Could be a good perspective to think about new revenue streams. I mean, at the moment we are in the discussions of exactly these kind of questions. What's a good balance? The issue with trade secrets is it's not IP. IP is obviously registered with a third party and validated if you want, and that's easy to look at. But trade secrets can be unilaterally declared according to some criteria set out in the Trade Secret Directive. And so the issue is always like, if you just allow, let's say, one side to say, look, I'm not going to share any data with you because it's all protected by trade secrets, but you can't validate that because it's a unilaterally declared situation, then obviously you get into a bit of a pickle. On the other side, when a trade secret is disclosed unlawfully, then it might lose its status as a trade secret as well, because the secret is public. And so I think for us the question is, how do we utilize, or let's say it like this: Parliament, Council, and Commission are 100% aligned in believing that trade secrets need to be safeguarded. So the question is just, how do we do it then in a way that doesn't stop the data flow randomly, but does it in a wide way? And it's, I mean, Federico, as I said, there is a question about dispute bodies. What if someone says it's a trade secret, but it isn't, or the other way around? And then there's a question of how to apply the Trade Secret Directive, because we have that directive. It includes sanctions of unlawful disclosure of trade secrets. How can we make these sanctions more binding? And how do we deal also with areas, geographies, where maybe trade secrets or the Trade Secret Directive cannot be enforced? And that's, I think, questions that we are asking ourselves right now in these negotiations.
Thank you, Damian. Jeremy, two very quick questions for you. First, how would the B2B provisions in the Data Act impact Microsoft's business, notably in relation to data originating from IoT devices and data potentially containing trade secrets? And second, the Data Act would also introduce an obligation for enterprises to share data with public sector bodies free of charge when responding to a public emergency. What's your take on that particular provision?
So on the first question, I think we're impacted in a couple of ways. We're impacted as a device manufacturer, naturally. So looking at where the scope actually captures some of the devices that we would manufacture and how we would design those in the way to comply. And again, I think that is relative, not straightforward, I would say, but again, where the definitions ultimately fall, we'll be like many other device manufacturers in that context. I think where the line is drawn between personal data and GDPR rights that already exist and the data that would need to be provided on top of that. Of course, we're looking at that. I think we're looking much, much more, and I mentioned it earlier, at the implications for cloud commitments that we make to customers to holding their data. We look at that very much in a GDPR context of controller and processor. There's customer data, and then there's everything else. We have agreements in place where we don't have access and rights to much of that data. So just wanting to be reassured that with the possibility to exercise this new right from users, are we a data holder in that context for customer data? I think that's where we see a bigger impact potentially on our business insofar as, understanding what end user rights are towards the ecosystem of players that might be holding some of that data, definitions around related service and the like. On the B2G question, one of the few things we did welcome in the proposal, and I think it's helpful to remind everyone, is the B2G, right, does not include law enforcement requests for data which have their own vehicles through which that data would be collected. So I don't think we stand ready to provide any data that we're required to, but I think we share some of those concerns that the Parliament and others have outlined about what constitutes an emergency, what would the data be used for, how broad of a definition is that. You can understand the concerns there. That's not from, it comes back a little bit to the cloud commitments that I mentioned and the personal data implications for that. So I think the Parliament has taken, a more appropriately cautious view, I hope, on that, and would like to see the balance land there. There's a wide berth there for what could be public interest and public emergencies, and I think we want to keep that scoped pretty carefully.
Thank you, Jeremy. Olga, I'm going to turn to data portability for you. The proposed regulation seeks to ensure that customers have the freedom to switch between different providers and retain control over their data. As a cloud computing provider, what are some of the challenges that Workday would face in complying with this element of the regulation, and what would be the benefits? Are there any specific technical or operational aspects that should be considered by regulators to ensure smooth and efficient data portability?
Thank you. So maybe building a little bit on my previous comment, we are supportive of the objectives that you outlined. Actually, a fundamental principle for us at Workday is our customers maintain full control of the data that they input into Workday applications, and that includes also when they decide to leave. So as of now, already all of them can retrieve their data free of charge in a fairly straightforward process that is available to them actually for at least 2 months. So a number of provisions in the Commission's proposal actually inscribe these principles into law, which we find very beneficial. So you asked about the benefits. And then again, with the more challenging parts of some of these obligations, again, there's a lot of difference between, if I as a consumer decide to leave one cloud storage and move my pictures and files to another one, it's a very different process than if one of our customers, a bank, for example, decides to move all its data and process it associated with 50,000 employees. So the changes that we see from co-legislators that actually reflect this difference is something that we definitely support. So if I can give you one example, we've seen proposals that actually distinguish between services delivered to consumers, to small and medium enterprises, and to large businesses. We very much welcome that both co-legislators moved from the initial 30-day timeline for the notice period as well as for the transition period. Because for some of our customers, these timelines are not feasible. But I guess what we really appreciated on the Parliament side is that they added that if both parties can equally influence the content of the contractual agreement, they could agree on an alternative notice. And what it does is, I think, on one hand, protects consumers and small and medium enterprises. Also, a little bit, in line with what was mentioned about Chapter 4, which legislators actually suggested to expand to all enterprises. But at the same time, preserves an important principle from our perspective of contractual freedom in B2B relationships. So these are the type of changes that we're supportive of. And if I can mention very briefly, one last thing is another positive development is really recognition of different roles that different actors play in the switching process. So I think there have been a number of changes that recognize that it's not only an outgoing provider, but also the customer, a third party that they might engage, and incoming provider that have a role to play in the switching process, which is typically, at least in the B2B space, a complex one. So thank you.
Thank you, Olga. We're going to switch to Q&A in about sort of nearly 10 minutes time or so. So please, audience members, if you want to ask questions, feel free to get your questions ready in the Q&A. We're looking forward to that. Panelists, we're running out of time, so I'm going to ask you to keep your answers to 1 minute, if you don't mind, for the next few questions. Federico, I'll come to you now. I'm keen to speak about the data, how the Data Act interacts with other EU law. Many in this audience will be familiar with the P2B regulation. Could you tell us how the P2B regulation and the proposed Data Act interact with each other? Are the stakeholders in scope the same, and what are the possible overlaps?
Well, as you said, there are many others, any other legislation, but specifically for the P2B, where there we are focusing on the online intermediation services. So what we are trying to make it a fairer contractual relationship between the online intermediation services, which is, for example, e-commerce marketplaces or online application distribution systems, where they are the users of these online intermediation services. Again, in an e-commerce marketplace, it could be a seller that use these marketplaces. It sometimes does not have access to the data related to its commercial activities. In the Data Act, what we are looking at really is a much broader contractual agreements for accessing data and for sharing data. So there, it's not really specific for the specificity that I was saying, intermediation services, but it's really any kind of contractual agreement that there are between, again, major data holders and small medium enterprises, so that they can access data produced and held by a data holder. And that is the main specific differences. I think I finished my minute.
Thank you, Federico. Olga, back to you. A lot of the discussions on the Data Act are focused on defining the types of data falling in the scope of the Act and ensuring that data sharing obligations won't endanger these trade secrets. What's Workday's point of view on the breadth of the data in scope of the proposal? And do you feel that companies' intellectual property will be sufficiently protected?
So again, focusing on cloud switching here, even though it's Chapter 6 is composed of a few articles, we have data and scope referred to in slightly different terms. So what we very much welcome is the European Parliament introducing a definition of exportable data applicable to the entire chapter. And what we also find helpful is, in our view, that it explicitly excludes data and metadata of the provider, which is protected by intellectual property rights or trade secrets. And For us, it's really about legal certainty and ensuring that we are not obliged to hand over proprietary data about our software. So we think it really, in that way, protects the data that is really specific to the internal functioning of our systems. It is really not of any use outside of Workday. This is very specific to one system. But we very much welcome that clarification. And even though Council did not kind of introduce a similar definition, it does introduce similar language in Article 24. So I think there is room here for compromise among co-legislators. And this is something that we very much would welcome to see in the final compromise. Thank you.
Thanks, Olga. Jeremy, the Data Act proposal excludes from intellectual property and access laws those databases containing data from products or services that are in the scope of the Data Act, such as sensors or other machine-generated data. What are your views on this provision? And do you think that data holders and how do you think data holders would be incentivized to invest in such databases?
Listen, I think there hasn't been as much discussion about that provision as there was fear at the outset. I think there's a decent balance that's been struck there. So it hasn't been as much controversy, I think, around that. I do think there are challenges if you go into a database licensing approach for that type of data. So I think we would actually welcome the balance that's been struck there. When you think about the way the data is expected to be used for AI and development, I don't think many would claim that the database directive approach has been a tremendous success. So I don't know if there would be a lot of incentive towards that. So I think that balance has actually been pretty helpful.
Thank you, and thanks for keeping that brief. We're going to wrap up now. Just by concluding, I'm going to ask all panelists one question, the same question, and that is, if you'd like the trilogues to achieve one thing, what would that be? I was going to give you 2 minutes each, but if you could keep it to one line or two, that would be great. I'm going to start with Damian, and then Olga, followed by Jeremy and Federico.
Just a general comment on where it's going.
Yeah, what you would like to see achieved from the trilogues. What's your priority?
I can only say it's Parliament's position, because I'm in the room. So at the moment, I hope that we will come up with it. Maybe one thing I can say is it needs to be clear. I think very often we think about more or less regulation, and that's too simplistic and actually not helpful. And what we need to ensure is legal clarity, so that even without a single lawyer, a company knows what kind of data they can share from the products they own, the connected devices they own. So that's, for me, an overarching goal that we should all aim for. And I sometimes feel that if we do lousy compromises, that suffers a bit on that side. And so I hope that whatever we come out with will be decently clear.
Great, thank you. Olga.
Just keeping it very briefly, we would very much welcome if the trilogue negotiations keep good changes that I mentioned around really reflecting the diversity and complexity of the cloud market. I'd say that's my one line there.
Thank you. Jeremy?
I would echo what Damian mentioned on legal clarity. I mean, the clearer this can be, the better. I think where our concerns are and where we'd like to see the trilogues land is ensuring that this isn't a legal analysis exercise by hundreds of lawyers for the next several years.
Thank you. And lastly,
Federico. And can I quickly add one point, because I mean, this has been mentioned now a couple of times. I think the general idea of Parliament's text, at least, and I don't know what would speak against it, is that cloud service provision is not really included in the scope of the B2B chapter. I mean, there's a whole chapter on it, but I mean, the idea of data storage as part of these provisions is not really the idea. Just to say this quite clearly, because you have mentioned this as a key concern a couple of times.
Thank you. Federico, you to wrap up, please.
I think that it has been said all. I think that the Council and the Parliament have done a great job and are doing a great job in order to clarify and make the Data Act more understandable. They also maintain the main objective. What we hope from the Commission is to reach soon an agreement, because as you know, the data economy and the digital industry and market is running at such a fast pace that we need to really come up with solutions that will foster also the European data market, and for that one we need to act fast and quickly. So let's hope that with the next trilogue, an agreement will be reached.
Wonderful. Thanks all. I'm going to move now to the Q&A part of the session. We've got about 15 minutes. We've already got some questions, and there's certainly time for a few more as well. So please keep them coming, audience members. If you'd like to ask a question, just type them into the Q&A box. The first one is going to be directed at MEP Boeselager, and this is from Emily Petras. She asks, how can we ensure that cybersecurity and trade secrets are properly protected when data flows from connected products to their users? For instance, how can we ensure users will be well placed to determine, together with data holders, the security measures that should apply when sharing data? Damian.
So yeah, I have to say two things up front. The first one is I have to leave soon because I have to go to the plenary and vote. And the second thing is I answered some of the questions already in writing, so just in case anyone is interested in the answers to those. And then the third thing is the answer to the question you just asked because it was too long for me to type, so I couldn't answer it right away. Look, in the end, with the contractual differentiation that we make, which basically says, look, you sell a connected device, and maybe as a manufacturer, you don't want to have anything to do with the data it generates. Yeah, and then you basically just out of the game because you don't want to have anything to do with it. Or you are actually entering into a servicing contract where you want to operate that device. And in that contract, you can obviously define all the details. So, like, I mean, we are still big fans of contractual freedom, and there should be, provisions that you both agree on what it means to safeguard trade secrets and so on. So this is all, for contractual relationships. So I hope that this will be covered via the contract.
Thank you, Damian. And the next question is going to be directed at the Commission. So if you have to jump out, feel free to do so now. And thank you very much for your contributions. They've been excellent. So the next question comes from Anna from the Lisbon Council, and this is for the Commission, for Federico. What's the European Commission doing on data beyond the Data Act, and how does the EU data space interact with the Data Act?
So this is the Data Act is the last legislation announced in the data strategy. This doesn't mean that there are not going to be, for example, sectorial legislation relating to data sharing and data access. However, what we are stressing is that the Data Act should be the basis, so the horizontal legislation upon which all the other data related regulation should be built upon it. So as I was saying, for the moment, from the horizontal aspects, we do not foresee, at least in the very short term, anything, and nothing has been announced. As regards the data spaces, we will continue to support the creation of data spaces in specific sector that has been announced in the data strategy. And there, what we are building up, what we are supporting the stakeholders to build up is really the infrastructure that will allow a secure data sharing between data holders and data providers. We are not, in this case, we are not mentioning only about data coming from IoT devices, but all sort of data. And there are already examples of data spaces building up, even without the support intervention of the Commission, where industries are willing to share the data. And we will continue to do that in the near medium term, really, because it's another way to share data on a voluntary basis. Yeah.
Apologies, I'm muted. Thank you, Federico. That's helpful. I'm going to skip one question just to give you a break, Federico. I'm going to go to Microsoft and Workday because Christina has asked a question. What are the main loopholes that you have identified in the Data Act? Would either of you like to take that?
I'm happy to. I don't know whether we call them loopholes. I think there is some ambiguity that is subject to interpretation. I think there's some concern around that. The way that Damian explained things, the way that Federico explained things, that sounds much more straightforward. I don't think the text is quite so straightforward. I think, as Olga mentioned earlier, there's a lot of complexity in a cloud ecosystem in particular, in cloud contracts and a switching process. I think there's a lot of complexity in some of the IoT environments around the implications for the B2B right. I think it sounds simple in terms of the aims. I think the text is far from simple. And I think we're going to have a lot of different interpretations potentially. So that's the thing I think we're paying closest attention to. Great.
Olga, would you like to come in as well?
Just really to concur what Jeremy said, and maybe also say that, I definitely subscribe to everything that has been also said about the legal clarity. Really think the respective compromises are not really quite there. So as much as the compromise could move, towards that clarity, I think that would be very much welcome.
Thank you, Olga. Okay, I'll go back to another question now for the Commission from Ilias. He's written, several organizations have called for sector-specific legislation like the access in vehicle data for topics that are not completely covered by the Data Act. Do you have any idea of any specific proposals that will come out soon on that? Federico.
Well, one has been mentioned. There are other Director General in specific sectors that are looking at the possibility. What we will do anyhow as Commission is to make sure that these sectorial regulations are necessary and that they are in line with the Data Act. As I was mentioning with the Data Act, we want to create an horizontal framework in order to share data. And we wouldn't like to have proliferation of other sectorial legislation in order to keep the sector and the legislation related to the sector as simple as possible. However, as I was saying, there might be needs for acting in specific sector, and that one we are looking at it and considering it, but I cannot announce anything right now. I'm sorry about it.
That's okay. I don't think they were expecting you to, Federico, so that's all good. We have another sort of 5 minutes for Q&A. We have one more in the chat, so please feel free, audience, to add a few more. In the meantime, we have a question from Luis, which I think can go to any of the panelists who wants to volunteer. So the question is, with regard to safety and security of products, do you think member states will show flexibility on introducing a provision by virtue of which it would be possible to contractually restrict or prohibit sharing of data on the grounds that such sharing could undermine the security of a product? Does anyone want to take that one? I see you all jumping all up at once. Is it? I'm trying to think. Is anyone at all qualified? Feel like they have anything to say on this or not? Maybe Federico, no.
No, it's difficult for me to answer these questions. I hope there will not be this, but on the other hand, as you perfectly know, the Commission has also set up a number of regulations regarding cybersecurity and security of products, which will first of all need to be applied. So I don't know. What we are trying to do is just to avoid the fragmentation of a market with national legislation. So I hope that one, such an approach will not happen, because it will introduce again a segmentation and a fragmentation of the market if it's taken at national level.
Thank you, Jeremy. You're unmuted. Do you want to come in?
Sure. I mean, I do think that has come up quite a bit in both the Chapter 6 requirements, the Chapter 8 requirements, arguably as well, and certainly the Chapter 2 requirements. You know, what are the requirements around cybersecurity and maintaining the security, and more security rather than the safety side, but more security of the data that's being reused. I think we have some concerns around that too in the switching process. And once again, I think there's just a bit of ambiguity there as to what the standards would look like in that context.
Great. Thank you, Jeremy. And thanks also to Christina for another question. She's asked this to all participants. What do you expect from the Spanish presidency regarding the negotiations for the Data Act? Will they finalize the work left by the Swedes? So again, obviously that's a difficult question to answer, but do any of you have any opinions? And if not, around the timing specifically, just maybe a different direction that they might be willing to take the discussions in? Who would like to go to answer that? Anybody?
Well, what I know, but it's since we are not directly responsible for the Data Act, it's difficult. It's just a feeling that I've got, is that both Parliament and Council, as with the Data Act, are really willing to let's say close the file, so to reach an agreement as soon as possible. It's the Artificial Intelligence Act. It's quite a difficult topics and a very topic that everybody are looking into today. So we are confident from the Commission that we will manage to get an agreement. But again, we are not the only one on the table.
Thank you, Federico. And anyone else want to come in? Jeremy or Olga? No?
No, I would say maybe I'd use the opportunity that, you know, everyone that we've continued to meet with and everything we've heard aligns to what Federico said, that, you know, there's really an expectation that the Swedish presidency would finish this. You know, that's understandable, but I do think it leads also to where some of those concerns we expressed earlier are. It seems to be much more important to get this done rather than to answer some of the questions. And maybe ending on a provocative note, it seems that all the questions we still have, most of the meetings say, well, that's just something will need to be sorted out during implementation. And that's always a bit of a challenge.
Great. And I mean, I think this ties in with the final question, which Emilia has also asked, which is how optimistic are participants that the next trilogue will result in an informal agreement? Jeremy, you kind of alluded to this a little bit in your last answer. Olga, would you like to come in on either of those questions?
Sure. I think just kind of repeating maybe a little bit what others said, from our engagement, we're definitely hearing similar reports that there is strong will to really the last trilogue to be the final trilogue. And I think we would have preferred if the Spanish presidency did spend a little bit more time kind of, really polishing some of the provisions and issues. It's actually the Data Act has been introduced much later than the AI Act, and we have it, the AI Act continuing for at least another 6 months. So I think from our perspective, Data Act is just as complex, yeah, again, we would have appreciated probably more time to engage, but it seems as the stars are aligned to finish in the next couple of weeks.
Wonderful. Okay, it's 5:02, so I think we can start wrapping up. Would any of the panelists like to leave any concluding comment for the audience before I just wrap the session up? I can go to Federico first if there's anything you'd like to say.
No, I would like to thank you for giving us the possibility to again explain what the Data Act and the main objective of the Data Act, and let's hope that the third trialogue will bring us to an informal agreement.
Thank you. Olga?
Similarly, thank you for having me and being able to explain some of the kind of very specific cloud switching aspects of the proposal. We're still quite hopeful that a lot of good changes are going to make it into the final compromise. So we'll be looking out for that towards the end of the month.
Fantastic. And Jeremy?
No, I also want to thank you for the opportunity. I think it's still very important to continue to talk about the Data Act. I know that we're trying to get close to a deal, and there's a lot of accelerated movements towards that. But I do think this is a very, very ambitious proposal that could have, very, good or potentially negative impacts. So the more we have a chance to talk about it, and then talk about it again after it's adopted, I'm sure, because there will be different interpretations. I appreciate the opportunity.
Fantastic. Well, our thanks to all of you, all our great speakers, for their fantastic insights today. I'm sure all of you in the audience will agree that they've been excellent and they've contributed a lot. And thanks to you also, audience members, for contributing with some great questions. I think it's been a really fascinating discussion. We've got a lot of takeaways. We'll see how this falls out in the end, either in this presidency or in the next. Jenny asked a final question in the feed about the recording. So we've got a recording of this event. We're going to send it to you all as soon as this is done, or at least within the next 24 hours. And just the last thing is to say, keep your eyes peeled for the next Inline DeHavilland event, which will likely be after the summer break. See you then. And in the meantime, if any of you have any political monitoring needs, please get in touch with DeHavilland. If you need analysis of tech regulations and any strategic engagement advice, come to us at Inline. We'd be very happy to help you. It's been a really great session. Thanks to you all, and have a great day. Bye-bye.